and welcome back to the Callahan Fusco Audio Network. Today, I am joined by Mallory, Kowalczyk, and we are going to be talking about RICO, which is like one of my favorite topics. We tried to do this podcast before. I messed it up, but we are back. Mallory, welcome to the podcast.
Thank you. Great to be back.
Yep.
And, very exciting. RICO.
Yep. So give me the breakdown on what a RICO is.
Okay, so RICO actually is a acronym, and it stands for Racketeer Influenced and Corrupt Organizations Act. So it's a real mouthful. And what it is it's a law that was passed in 1970, signed by Nixon and all people, and it was aimed at addressing the organized crime, mob crimes, these big organized systemic family crimes and the term family loosely, but who use low-level criminals to do their dirty work, so to speak. And so law enforcement had a very difficult time getting to the head of the snake.
Right.
And so this act was passed to effectively enable law enforcement and prosecutors to stop the fraud where it starts, and it's the head honcho.
Right.
So there's a criminal side and a civil side, and so we're going to be talking about the civil side because we do civil.
We do civil.
And criminal is not my area of expertise, but it's very interesting. And the civil side is extremely important.
Right.
Because as you know, I'm sure, a lot of these white collar, these big fraud crimes, money is where it hurts.
Right.
I imagine prison's not all that fun.
No.
But, for a lot of people, money talks. And so the civil side enables private parties, which could be, insurers, it could be individuals, it could be companies, whatever, to sue under RICO for violations of RICO, and then win treble damages, which is 3 times the amount of the injury plus attorney's fees and costs. So it enables people to take the risk, if they are successful, of going after these big fraud groups and networks, which are tough, because then if you're successful, you get that back and you get your attorney's fees. So it really was helpful in that sense. And there's state RICO, there's federal RICO, they all kind of work hand in hand, but generally there's 3 parts, I'll say, because the elements are specific to the actual statute. But you have to show that there was an enterprise, so that's the organization part of it. You have to show that there's a pattern, and that could range from I think 2 is the lowest to oftentimes it's 5, but just more than one instance of whatever that is, and then just a harm, so that the pattern caused a harm financially to whoever is bringing the suit.
Got it.
Yeah.
So how does this affect the PI firms?
Okay, so RICO is what we call it's affirmative.
Right.
So we're saying that we have all this data, all this information. Let's say we're an insurance company or FedEx or Uber, some of the companies that have been really at the forefront currently of some of the over 20 RICO actions filed in the last couple years. And so they are affirmative. We do defense work. So what that means is somebody is suing us. We'd only have access in our proofs to the file before us unless we can prove that it's all relevant, whatever. So they're not apples to apples. So they are so helpful, though, for defense firms because in only having access to our one case, it's difficult to prove a pattern. It's difficult to find a pattern. Framing
So proving
patterns,
a pattern is important.
Correct. It's necessary. It's a requirement. So framing what a pattern is one thing legally, but finding these patterns can be tough within one case. So you can look at these RICO cases, these lawsuits that are 400 pages, some of them, that show the enterprise, which in our situation is oftentimes law firms and attorneys, providers, chiropractors, PTs, surgeons, orthopedic specialists, et cetera, and sometimes even the plaintiffs themselves, that we might see in our matter, but it could look just like, all right, this is treatment.
Yeah.
But when you read these RICO suits and you see how all of the providers interplay and how there's outside money that we don't know about because it's not part of our suit, that they're getting kickbacks from. There's a lot of information that, you know, these big companies have access to that we just don't hear.
Right.
So it gives us the ability to say, oh, I didn't even think to look for that because it didn't strike me as something that's applicable. But now I know what discovery to ask for, what deposition questions to ask for, you know, what patterns we are able to create based on information that I've learned elsewhere.
Yeah.
So it's really, really helpful. And also, I'll say it's broadly important because we get to see how courts that we practice in view these types of allegations of fraud, view these types of, allegations of wrongdoing against, let's say, attorneys versus providers versus, you know, the plaintiffs. And it could be the case that some jurisdictions, let's say New York, are really hesitant to believe, you know, that the providers are in on it, but they're fine with the staged accident portion, or you know, whatever the case is. So then we know what we have to like really focus on in our proofs, the areas of weakness that we're going to, you know, and bias maybe that we're going to face. So it gives us a good idea of what to prioritize and focus on when we're defending if we see these things, these providers, these people in our matters.
Yeah, so it's funny that you bring up the deposition thing too, because Sarah literally was just on this podcast talking about like.
Oh, so great! Sarah's great. I could listen to her teach me about deps forever. She's so good.
So she was talking about depositions in the sense of like you need to like learn about your client, but I guess when it comes to like RICO cases, it's much. Do you think it's much different at all when it comes to learning about them?
So I think it's. Every deposition is different in a lot of ways. So, you know, it depends on who you're deposing.
Yeah.
And so if we're deposing our plaintiffs, there's a lot of information we need to get that's specific to, you know, defending the allegations in the complaint. But for us, we also have an obligation to defend affirmatively and say, well, even if, you know, there was an accident, even if you did actually get this treatment, it was all a product of fraud or, you know, whatever the case may be. And so it's the deposition focus is kind of a plus instead of different in general. But if you're, let's say, deposing a provider, a treating provider versus an expert provider, because those two things are different, who we think is involved in the fraud, you know, that's also extremely different than a normal provider deposition that where you're just trying to figure out, like, you know, whether causation was sufficient, you know, and things like that. You're actually trying to get from that provider information that might corroborate the things that you've read in the RICO investigations or might corroborate some suspicions you have in viewing the records. So, you know, the deposition is so important because it bases any future requests for discovery, documents, etc. You could use the testimony from their own mouth to say, well, look, judge, this is why we need this now because of this. So it's and oftentimes judges want that first before, you know, they agree to expand discovery or whatever. They really want the basis for the request to come from a deposition. So it's a necessary tool.
Gotcha.
In a lot of cases.
So how can attorneys use these lawsuits to help defend clients in PI actions? Well,
so I don't. These lawsuits, these RICO lawsuits, are, you know, like I said, incredibly useful for us to tailor our investigation, target our discovery requests, and things like that. But you don't want to use allegations as, you know, your quote direct evidence of proof, because that will never fly. You know, you can't evidentiarily and just kind of public policy wise, you know, you don't want that. Anyone can sue anyone, right? So we have to take them with a grain of salt and try not to over rely on them as far as in our defense. But they are important to kind of give credibility to our fraud narrative, what we're saying happened in our personal suit, because some of these, you know, some of the things we're finding in these investigations into our matters and the fraud and the stage accidents and things like that are so wild.
Yeah.
I've done fraud work for over 10 years now.
That's what she does for the firm, by the way.
Yeah, so I am the fraud attorney. But, so I've done this for over 10 years, and I am still shocked sometimes. And you really have to see it to believe it.
Yeah, we've talked about this before. Like when there was a time where I was helping Mallory out for a little bit, and some stuff that I've seen has been kind of wild.
Yeah, I mean, we have things where, an alleged accident happened, and our truck driver, our client's driver said, I don't know what this person's talking about, and then come to find out it was, the person wasn't even in the country, or something crazy where if you do not see the hard proof of it, you would not believe it.
Yeah, and people think they can get away with stuff like that too, which is crazy.
And because they do.
Yeah,
I mean,
they
we're
do.
even seeing in these RICO suits that there is so much reticence to, acknowledge that this could exist. I'm talking billions of dollars in settlements in court and whatever, and that judges have been fleeced for a very long time.
Yeah.
And it's hard to be a judge for these types of cases. And a lot of judges, I imagine, are not the happiest when they see that they are assigned a RICO case, because it is so dense, it is so fact specific, and the discovery and all of the litigation that goes into it is very, the stakes are very high too. And so, treading that lightly is important, but also convincing the judge, like, Judge, I'm not saying this as, a zealous advocate for my client. I'm saying it because this is what the facts are telling us. And you don't have to, take my word for it. Like, look, these other people broadly are showing this as well. Again, allegations, but I have the same facts.
Right.
So it is what it is, And so I think, towing that line is really important, but it does need to get out there.
Yeah.
Because they have access to the data and the details and the documents that we don't necessarily.
Right.
So, it is incredibly useful, but as a checklist and as a credibility booster and a support, as opposed to, a cut and paste or whatever. We can't use those allegations definitively, but we can use them very, very intentionally and usefully.
Yeah. I mean, this is a really insane topic.
Oh, I could go on for so long.
Yeah.
And this is just RICO, right? There's other state statutes, like New Jersey has the IFPA, the Insurance Fraud Act, Consumer Fraud Protection Acts, and things like that in different states. So states have also made their own versions so that you can do both, and you don't have to necessarily bring it in federal court.
Yeah.
Or whatever the case may be. So so it's very interesting, and I love it because, like I said, the exhibits, the attachments, the support, the discovery that is produced in these cases as they get filed or whatever, they're so informative. They're so useful because they also have teams and teams of people who this is their only job.
Yeah.
So, whereas like everyone here, we're all trying to do everything and in the best way possible, but it's easy to miss or overlook or not realize the importance of a piece of evidence because you don't have a more complete picture. So, very, very glad.
It's a crazy good topic.
That this is the time that I am doing this work when they are also doing this affirmative work.
Yeah.
So.
Well, you're the best as usual. Thank you for joining me on the podcast
awesome.
Today. If you guys want to see more content on RICO or anything that Mallory talked about today, please leave us a comment down below. Like and subscribe to the channel. This has been the Callahan Fusco Audio Network, and my guest today is Mallory, and we will see you guys on the next one. Thank you so much.
Bye.